Welcome, everybody. It's really nice to see everyone. It's been a while. It's fun to get together. Thank you. Thanks for coming this morning, or this afternoon, I guess, for our spring meeting. I know you all have very, very busy schedules, so again, we always appreciate your work and attendance. Welcome to the formal spring meeting of the Advisory Committee for Diversity in a Digital Age. I think we might as well just get right to the agenda, and I turn it over to the chairman.
Thank you. Let me add my welcome also. We're awfully glad you're here. We continue to work. The chairman has seen fit to recharter the committee and reappoint. Most of you have served on prior iterations of this committee, so thank you for agreeing to serve once again. The task forces have not been idle. I think some of you have heard from your task force chairs already, and we'll hear the status of all the task force work in the task force reports this afternoon. So, as you can see, Commissioner Clyburn has agreed to grace us with her presence again. We really appreciate your coming, Commissioner, and I'd like her to address the group because she may have to run off before we're finished.
Thank you, Chairman Rivera, and good afternoon, everyone. I appreciate you for allowing me to share some brief thoughts to the reconstituted, but ever committed, Diversity Advisory Committee. To those familiar faces around the table, it's great seeing you again, and thank you for remaining committed to fueling opportunities, whether through innovative non-regulatory measures or, when necessary, regulation. So thank you very much. To those new members, some good friends in the audience also, but thank you so very much and welcome. Service on our advisory committees requires considerable time and effort, but please don't let that scare you. We benefit so tremendously from your advocacy and counsel, and we thank you very much for what you will do. The Commission has made some very real progress from this committee's recommendations. In part, when we formed a Native Nations FCC Broadband Task Force, we have benefited so much so that we actually created an Office of Native American Policy that's headed by Jeff Blackwell. The dedicated ONAP staff has engaged in robust government-to-government consultation and currently assists the Commission in developing and implementing policies for bringing modern communications infrastructure and services to all tribal nations and Native communities. The FCC has also been working diligently on this committee's recommendation to implement an outreach program that will proactively seek to increase awareness of the benefits of lending to and investing in minority and women-owned industries, particularly when we talk about broadcast properties. Further, we've been working to implement your recommendation, including what ACBO is doing, as it relates to its website or our website, providing up-to-date and easy-to-assess information that can assist new entrants and mature entrants, mature properties in broadcast media. Those are about a couple of examples of the contributions this committee has made to the Commission's work, but your dedicated strength in helping to push the boulder up the mountain on reforming inmate calling services, which my office cares so much about, which is impacting millions of undercapitalized families, is to be commended, and I thank you for your support on this particular effort. For it is for your and because of your wise advice and counsel it's truly helping me. And it is augmenting what I know and what we know is best, that when we are in this regulatory space and when you are dealing day to day in your businesses, that it's important for all of us not to ever rush to judgment while considering reforms of, say, our media ownership rules. And as we look forward and towards the nation's first ever spectrum incentive auction scheduled for next year, your advocacy in assisting small businesses who could benefit from the auction will be welcome and is very necessary. I've read, you might not have heard this, Mr. Chairman, that in the coming weeks, the FCC may be going through a transition period of sorts. Have you guys heard anything about that? Well, anyway, seriously, Section 257 of the Communications Act, it still directs this agency to identify and eliminate market entry barriers for small businesses and to promote policies favoring a diversity of media voices, vigorous economic competition, and technological advancement. And until or unless they strike that language from the Communications Act, and I suspect they will not, I expect this agency, aided by this committee, I suspect and expect that we will do our level best to actualize all of the objectives as laid out in the Communications Act. So again, thank you so very much, and I look forward to this engagement today.
Thank you, Commissioner, so much for those encouraging words. We appreciate it very much. Barbara, did you want to take roll of those on the phone?
Yes, everyone on the phone, hello. You want to identify yourselves. That's a scary start. Anita Graham, are you there? Is the phone on? I did check before the meeting. I see Flurry in the control room. I have the table. It just goes on the phone. I was trying to. Why don't we just go around the table and everyone identify themselves, and let's get reacquainted while we're waiting.
Right.
Want to start?
Yeah, Jim. Why not?
Jim, go ahead. Go for it.
Some people here might get tired of me talking. But I'll simply begin by introducing myself. I'm Jim Winston. I'm the Executive Director and General Counsel of the National Association of Black-Owned Broadcasters. We're a trade association representing the 200 or so Black-owned radio and television stations around the country. And I've been pleased to be a member of the Diversity Committee since its inception.
Eric Broyles, board member of McGree and CEO of an investment research firm, Expert Connect.
Hi, I'm Celia Nogales, and I'm with AT&T, and I'm in the Federal Regulatory Office here in Washington, D.C.
Hello, my name is Charles Farrell II. I'm the president of the IT Architect Corporation, and honored to continue to serve on this board since September 2011.
Hello, Marcellus Alexander. I'm Executive Vice President of Television for the NAB, National Association of Broadcasters. I also have the privilege of wearing a second hat as President of the NAB Education Foundation, and I'm sitting in today for my colleague Aaron Dozier, who's out.
Hi, I'm Tony Bettis, and I'm with the National Association of Telecommunications Officers and Advisors. It's a national group that represents the local and community interests in communications and more so in broadband. Happy to be here, looking forward to a meaningful engagement.
Hi, my name is Jeffrey Lee. I am the General Manager of WHUT Television, and I'm representing not only WHUT, but public broadcast, public media.
Good afternoon. My name is Bridget Daniel. I'm Executive Vice President of Wilco Electronic Systems. Wilco is a private cable company located in Philadelphia, minority-owned, and we've been serving the community for about 30-plus years. Very honored to be reappointed to the board, and glad to resume the conversations. Thank you.
Thank you. Good afternoon, everyone. My name is Sherman Kizart. I'm the Managing Director of Kizart Media Partners, which is a media consulting and marketing firm based in Chicago, and I'm certainly happy to be here today and honored to have the privilege to continue to serve on this very important committee.
Thanks. Appreciate it. I have two microphones.
Oh, you got two.
Pretty popular. That's all right. Rudy Brioche with Comcast, NBC Universal. Good to see a lot of familiar faces here. And just here to be part of the discussion. Thanks.
Great. Hi, Steve Roberts, Roberts Broadcasting. I'm one of the few beings here that hopefully won't be extinct shortly. I'm one of the few minority-owned broadcasting groups left in this country. We have a station, as a commissioner know, in Columbia. We have 4 stations throughout the United States. There are total, according to Jim Winston's recent report, there are 6 minority-owned broadcasters in the United States. And it's really very sad for our country because, when we started in this business 20 years ago, it was 20 minority and women owners throughout this country, and today there are 3. So there's a problem. I mean, there's a real problem for all of us around this table. But I'm here. Thank you for honoring me the opportunity to serve for 2 more years with you. I won't be as quiet as I was, Commissioner, the first 2, because I understand what we're trying to do here. But we have a big task ahead of us to preserve the opportunities for all of the citizens of this country. So Steve Roberts from Roberts Broadcasting, and as Tom Reed knows, I'm always available to answer any questions and give you insights. But I still think it's a wonderful business. We just need to have some tools to encourage both minority and women-owned businesses in this area. So thank you.
Good afternoon, everyone. My name is Nicole Turner-Lee. I'm the president and CEO of the National Association for Multi-Ethnicity and Communications, NAMIC for short. Glad to be reappointed back to this committee. I'm also the chairperson for the Unlicensed Devices subcommittee, of which several of you are on. Just to give you background on NAMIC, we're actually interested in advancing diversity and inclusion among people of color in the media and communications field, both on and behind the scenes. We also are in the business of creating champions of diversity, regardless of race or ethnicity, to ensure that this is a strategic business imperative for the industry in which we serve. So glad to be here representing thousands of members across the country who are pretty much aligned with our mission and goals.
Good afternoon. I'm Ronald Johnson, and would like to say I'm excited to be here again and to have the great honor of serving as chairperson of the Supply Diversity Committee. Thank you, Mr. Chairman, for that, and we're looking forward to the challenge this year. I'm the president and owner of 2 companies. Ronson Network Services is engaged primarily in building out infrastructure for wireless and wireline companies, and Solutions for Change, which primarily is engaged in trying to find ways to get large and small businesses to work more collaborative together, and you'll hear more about that shortly.
Hello, I'm David Honig. I'm the president of the Minority Media and Telecommunications Council, MMTC. Our mission since 1986 has encompassed equal employment opportunity in media and telecom, minority and women business ownership, and closing the digital divide. We also operate the only minority-owned and only nonprofit media and telecom brokerage. We have a radio station group, and we train fellows and attorneys in the practice of telecommunications law before the FCC.
Hi, my name is Carla Ballard. I'm Managing Director of the Broadband Opportunity Coalition. We just completed 3 years of working on addressing the issue of broadband adoption. Really excited about leveraging those assets so we can further that mission. I'm also Senior Vice President at Ogilvy & Mather.
Thank you. Good afternoon. My name is Daisy Oj Dominguez, and I'm Vice President of Recruitment and Organization and Workforce Diversity for the Disney ABC TV Group. I am representing the Walt Disney Company today, and I am honored to be a new member and to be part of this important work.
My name is Joseph Torres. I work for the public interest group Free Press, taking the place of Coriel Wright, who moved on. Besides Free Press, I'm also on the board of the National Association of Latino Independent Producers, Filmmakers and Artists Group, and I'm also on the board member of the Center for Media Justice.
I'm Andy Schwartzman, and notwithstanding what it says in front of me, this is not the Commission's fault, it's mine. Media Access Project, which it says I'm at, was shut down about a year ago. I was president of Media Access Project for about 34 years. I'm now a senior advisor to Free Press, and that's the capacity in which I sit on this committee. I've been involved in issues pertaining to minority ownership, diversity in programming, and similar matters for some 40 years. And in that capacity, I hope I can help the work of this committee.
Welcome, everybody. My name is Thomas Reed. I'm Director of the Office of Communications Business Ops, OCBO, here at the FCC.
Hi, good afternoon. My name is Ruth Ann Deutsch, and I'm a Senior Counsel at Aiken Gump. We worked with MMTC and a group of former FCC commissioners in preparing an amicus brief in support of the University of Texas in the Fisher case that I'll be talking about later. And thank you very much, Chairman, for inviting me to share.
Good afternoon, everyone. My name is Phyllis Eagle-Olson. I'm President and CEO of the Emma Bowen Foundation, a pipeline diversity initiative supported by the media industry, and I'll be telling you a little bit more about our program a little bit later on the agenda.
Good afternoon, everyone. My name is Jared Hill. I am a reporter with WMDT, the ABC affiliate on the Delmarva Peninsula. I'm also a graduate of the Emma Bowen Foundation, and we'll be talking to you all about the program.
Hello, my name is Sonia Morgan, and here I represent Jose Martin. I'm Executive Vice President from LISTA, Latino Information Science and Technology Association.
Good afternoon, everyone. My name is Virgil Smith, Vice President of Talent Acquisition and Diversity for the Gannett Company. Those who don't know Gannett, it's a news and information company with 100 properties across the country.
Good afternoon. My name is Carolyn Fleming Williams. I'm Senior Deputy with OCBO, and I'm also the Deputy Designated Federal Official for this committee. Welcome to both new and returning committee members.
Good afternoon. My name is Jason Legria. I'm a Senior Staff Attorney at the Asian American Justice Center, which is a national civil rights organization.
Hi. Hello. Jessica Gonzalez with the National Hispanic Media Coalition, nonprofit organization dedicated to improving the image of Latinos as portrayed by the media, increasing employment opportunities and ownership opportunities.
Hi, I'm Sylvia Strobel, the Alliance for Women in Media, which promotes the advancement of women in all media forms. I served on AWM's National Board of Directors for over a decade, and I've been told I have a lifetime appointment to its Public Policy Committee, so I'm here today for that.
Hi, I'm Maria Brennan, President and CEO of Women in Cable Telecommunications. I, too, have been on the committee since its inception, and I look forward to working with all of you. WIC works to create a pipeline of women who are ready to lead, and we do this by commissioning original research and by creating educational opportunities. So thanks.
I'm going to try the phone one more time. Anyone there yet? They're still working on it. Oh. Hi. Welcome, phone. You want to
yes, Bill Bradham's here.
Hi. Welcome, phone. I think that's me.
Yes, Bill Bradham's here.
All right, we'll just.
Diane Sutter.
Hi, Diane.
Hi, we've got feedback on this call. Looks like there's another call going on simultaneously.
That's weird. There's another call.
I think we'll just proceed as we get it straightened out. Sorry.
We're trying to get it straightened out, Diane.
This is the FCC.
Thank you.
Okay.
Joanne Haller. I'm sitting in Anton Catano, CBS Radio.
Great. Anybody else on the phone?
Yes, Bill Branham's here, 21st Century Telecommunications.
Thank you.
Anybody else? All right. Well, as you can see, you're a very impressive group with a tremendous amount of talent and resources that we hope to make use of as we move forward. So again, welcome to all of you, and thanks to all of you for your willingness to share your time and your expertise with us and with the Commission. With that, I'm going to turn the floor over to Tom Reed, who's the Chief of the Office of Communications Business Opportunity, who's going to give us an update. Tom.
Thank you, Henry. I guess you all noticed that these mics are on, I think, 5-second delay. So, just in case anybody wants to say anything inappropriate, they'll get blocked. Anyway, good afternoon. Thank you for the opportunity to address the committee, and more important, thank you, Henry, for your continued commitment to this advisory committee and the important work it does for the FCC. I'd also like to thank all of our returning committee members as well as the few new faces we have in this group. Again, welcome and welcome back. The advisory committee's task is to work creatively with the FCC to see how the private sector, public interest groups, government and other stakeholders can identify and maybe even create opportunities in the marketplace for women and minority entrepreneurs. How we can improve access to internet and communications technologies so that all Americans are engaged civically and have their educational, professional, and personal needs met by the prevailing communications technologies. A simple task. We're essentially asking you all to help us figure out how to make the world a better place. So we're going to be busy. In fact, this committee has been doing just that type of work for many years up to now, and its efforts and expertise continually influencing FCC policy, and its work has been the genesis of many of the agency's current diversity initiatives. Thank you for your patience while we work through the rechartering and reappointment process. We are very excited that this committee can now continue the work it began in 2011 and 2012. A couple developments at OCBO since we last gathered. We've received a final research design for the study of the critical information needs of the American public and how the media ecosystem serves these needs. We anticipate that we'll be releasing the research design very soon for public review and comment, so stay tuned for that. Also, on July 11 of this year, we'll be holding our next Access to Capital conference here at the FCC. This time, though, we'll be focusing on angel investment. So before I finish up, and again, I'm going to be very brief, I'd like to recognize Barbara Kreisman of the Media Bureau, Carolyn Fleming-Williams, OCBO Senior Deputy, and Nicole McGinnis, who's not here. She's not feeling well. I think she's caught that bug that's going around. They are all going to be continuing their work with each of you as you serve the committee and each of your subcommittees. Like you, they commit this time over and above their already significant workload, so my heartfelt thanks go to them as well. I'd like to recognize our subcommittee chairs, Diane Sutter, I think who's on the phone. I think her group is looking at the history of the tax certificate and the impact and effectiveness of other diversity initiatives. David Honig, who's with us, EEO Best Practices, Nicole Turner-Lee, Unlicensed Devices, Ron Johnson, Supplier Diversity. We'll be hearing, I think, from each of them as they discuss the status of their work and their ongoing mission. Susan Patrick also chairs the subcommittee on Channels 5 and 6, and that issue was specifically whether that space could be a viable home for AM station owners. Just as an FYI, we have asked Susan and her team to hold while the Commission continues to examine spectrum allocation and incentive auction issues. So one final plug. If you haven't yet joined a subcommittee, or if there's a particular issue you'd like to work on, please do contact Henry or one of our designated federal officers and let us know your preference. Our aim is to determine where this committee's broad and significant expertise can be best utilized, particularly on issues that are under consideration by the FCC, where real-world knowledge and experience can benefit policy determinations. I'll be working with Henry and the designated federal officers as well as other subject matter experts within the FCC to identify additional questions that are appropriate for this committee's consideration. So thank you again. I'm looking forward to the next 2 years, the duration of the current charter for this committee, and I know it'll be productive.
Thank you, Tom. Does anyone have any questions for Tom?
5-second delay.
I don't know if Tom's going to have any answers, but
right.
All right, seeing none, we'll move to the committee reports, and we're going to start with Ron Johnson. You're up first, Ron.
Okay. Thank you, Mr. Chairman, Commissioner Clyburn, FCC staff, fellow committee members, and ladies and gentlemen in the audience and who are calling in. As all of you all know, the Commission in recharting the Diversity Committee has given it 4 primary tasks to do this year. We think that among these tasks, the third task, the one that has been given to us, is extremely important to not only the work of the FCC, but to the work of all of you all that are in this room today. That third task is to have our committee to continue to work on how exemplary supply diversity practices by industry participants can contribute to the FCC's goal of ownership diversity, which is important to all of us. Embedded in this broad charge is the work of our task force. Chairman Rivera has charged us to, and appropriately so, to focus in on this particular subject because of its interest not only to him but to all of us. And specifically, he has asked us to look at industry procurement best practices as a way of getting to the heart of this issue. It is our expectation that our task force will be able to identify procurement practices from many businesses that have led to removing barriers to entry for small minority and women-owned firms around the country in various sectors of our industry. That is our hope and that is our challenge. Now, on the surface, this might seem to be a less than daunting task for our group to undertake. However, the gathering of procurement data from competitive industries is not undaunting. It's a very difficult process. So the challenge for our task force is to find the right balance of data gathering, data analysis, and data synthesis and dissemination, and out of that fashion hopefully some policy perspectives so that the FCC can reach many of its objectives in the diversity area. It is not surprising that companies like yours and like mine, and certainly large businesses, go to great lengths to guard their procurement practices, particularly if they are good practices that lead to increases in the bottom line. After all, they are very competitive, as we all are, and so therefore they would want to protect all of their best practice information. So it is going to be very difficult, we think, for us to get the information that we need from these companies, but certainly with Tom's help and the help of other organizations around this table, and certainly our committee members, we should be able to do in this. And now Tom has, I have asked him to help us with this, and he has agreed to do so. As you all know, Tom has great insight and passion for these things, and we look forward, Tom, to working with you again this year. I think that one of the things that I want to mention to you is that last year we did work with Tom's organization, his group, with the conference we had here. If you would like to go back to last year's FCC website, perhaps you'll be able to see the event that Tom put on. I think it's very informative, particularly if you're in this business, large or small, it really doesn't matter. We had a wonderful time talking to large and small businesses about some of the problems that they're having on the large business side in attracting smaller businesses, and from the small business side, how to engage in doing business with these large companies. And we want to continue that strategy in the next year. And so I think from most perspectives, Tom, this was a success, and we look forward to working with you again in this. Now, Tom has also been helping me get ready to kick off our task force this year. We've been successful, or at least we are trying to get more engaged in trying to provide or look at subtask strategies and some measurable objectives for our task force. And so we are continuing looking at ways to engage all of our members to make the best use we can of their time and their resources. And so that is the most important thing for us right now, is to try to find ways to do that. The members that Chairman Rivera has appointed to work with me and Tom, I think, represent some of the most accomplished folks in the industry with great insight and with great experience. And you might not know all of them, so I would like to just introduce them to you right now very quickly. From the National Urban League, Chanel Hardy. I don't think she's in the room today. Charles Harrell from the IT Architect, he's with us. Faye Kuar, who is the Communication Services for the Deaf. Cecilia Nogales from AT&T, she's with us. Javier Palomero from the United States Hispanic Chamber of Commerce. Dr. Sidney Schauf, the Asian American Chamber of Commerce. And Mark Wallace from Cipher Communication. Please join with me in welcoming our new members, our continuing members to the task force. Now, Mr. Chairman, I and the members of our committee believe that diversity is a great pillar of American society. It is the cornerstone which fuels and sustains the economic growth of the telecommunications industry. And with that said, we look forward to working with all of you all this year and to come back at our next meeting with a very sustained report about what we've accomplished and what we look forward to undertaking in the future. Thank you, Mr. Chairman.
Thank you, Ron.
Okay.
Anyone have any questions of Ron? I just want to underscore something that Tom said earlier. if you're not on one of the subcommittees, pick one and get on it. And if you're already on one and you want to get on another one, that's fine too. So we encourage you to get involved and not to wait for the invitation. So just send me an email or send Barbara an email and just let us know what your preferences are in that regard. So no questions for Ron? All right. We'll move on to Diane Sutter, who's on the phone.
Thank you, Mr. Chairman. My apologies to the group for not being able to be there in person this time. I'm actually in the middle of a 3-day seminar, and I'm sneaking out of the meetings to be on this call. The subcommittee on barriers to entry has been tasked with reviewing the tax certificate, the history of the tax certificate, and trying to provide insight and guidance for the full committee as we move forward in determining what options might exist and what was the environment when we first had the tax certificate and where are we now. The committee met last year and again just recently to determine how the best efforts could be put toward this. And we have divided the subcommittee into 2 task forces. The first is the anecdotal task force, and they will be working to identify the individuals and companies that were involved in using the tax certificate from the period of time when it existed previously, which was 1978 to 1995. We hope by identifying these individuals and companies that we can put a face, if you will, on the tax certificate so that we can provide information to both the Commission and hopefully to Congress on how this was used successfully both by companies and individuals to further minority ownership and activity in the business. As you know, at the time that the tax certificate was in full force, it was related to minorities, and of course we would be looking to recommend the expansion of this to include women and minorities as we move forward. And we have begun to identify individuals who use the tax certificate and are working to expand that list. The second task force is the historical task force, and their goal is to gather the factual information on the use of the certificate itself, identify the number of certificates that were issued and what has transpired with them and since then. And the task force felt it was important to also provide context, to look at the industry, what it looked like before the tax certificate was implemented in 1978, and then what were the outcomes under the program, and what has been the result for women and minority ownership since the tax certificate was eliminated. So looking at prior to the implementation of the tax certificate, during that time, and after that. So we also want to make sure that as a committee we look at all forms of communication beyond broadcasting and cable, which is of course where it began, but recognizing that the communications environment has changed, broadened, and grown, so that we want to make sure that we include all of the things that might be used under this tax certificate. We have begun to identify also various communications, articles, white papers that have been written on the subject of the tax certificate, again to gather historical and anecdotal information. In your committee report, we have listed some of those people. This is the beginning, hopefully not the end, of the list of individuals and companies and resources that we might be able to identify. I would like to ask every member of the full committee if you would take a look at that list. I am sure each of you have knowledge of other people, companies, or articles that have been written. We have provided you with the articles that we have and are looking to grow that list. So if there are individuals that you know of that you can recommend to the committee, I would certainly appreciate your doing that. If there are information or stories that you have that you could relate, we would look forward to hearing from you. The members of our
has left the conference.
the members of the task force will be working on each of these particular areas as we move forward and trying to develop the most comprehensive look we can. Tom will probably be needing to work with the commission, and Barbara, you might also be able to guide us to try and get actual numbers of the certificates that were issued, so we'll be looking to work with you on this too. That, Mr. Chairman, is the activities that we have had up until this time. The members of the task force, many of whom are in the room, and I would ask as I mention their name, if they're there, to please raise their hands so that everyone can see who you might be able to talk to. Maria Brennan with Women in Cable and Telecommunications, Anton Gaetano with CBS, Walter Aloa from Entravision, Tony Perez with the National Association of Telecommunications Officers and Advisors, Joe Torres of Free Press, Bridget Daniels with Wilco Electronics, Herman Kizart, Kizart Media Partners, Eric Broyles, McGree, and Jacqueline Clary is also our rapporteur, and Anita Stevens-Graham with Opportunity Capital. So thank you, Mr. Chairman. Those are the activities of our committee to date.
Thank you, Diane. You mentioned a list that the committee might have in front of them, and I just wanted to give you a heads up. We do not have that list. So if you're able to send that...
Jose Marquez, Latinos in Information Science.
If you're able to send that to Barbara, then she can pass that out.
I will be happy to do that, and also the articles that we have gathered up to this time. So I will be happy to do that.
Great, thanks. Any questions for Diane? Yeah, Jim.
Diane, it's Jim Winston. I'd like to volunteer to be on the committee.
Done.
Is that Jim Winston?
Yeah.
Wonderful. We welcome your joining us, and you've already been very helpful already in supplying some information for us, Jim, so thank you.
Indeed you have. Yes, Bridget.
Not a question, but a statement. Just wanted to say that this committee is very important, so thank you, Jim, for joining. Diane, this is Bridget. But I wanted to just mention that we had the chance to, Wilco, bring Commissioner Clyburn recently to Philadelphia on Monday to talk about this issue in Philadelphia. In Philadelphia right now, there's a cable company such as Wilco, there's a black radio station, and also a black publication. So we had the opportunity to have Commissioner Clyburn here to just talk about the issues. So just want to let you know that you can bring this issue to your community, and it's important to spread the message of the FCC because a lot of people really don't know that message. So just wanted to say thank you for that opportunity.
Thank you. Anyone else? All right. Thanks for that report, Diane. You can go back to your seminar.
Oh, no, I'll still be here, Mr. Chairman.
Atta girl. All right. We'll move on to Nicole's presentation.
Thank you, Mr. Chairman, for that. Tom Reed, Barbara, fellow committee members, ladies and gentlemen as well. I'm going to actually do this as both a commercial and a campaign to get more members to our committee. So when I do my updates, I expect people to also raise their hand because we're on an area that is probably not as sexy to our industry, but very necessary when it comes to unlicensed devices. So I'll speak a little bit about where we were and where we're going with this particular subcommittee, just very briefly. Last year when we started this conversation around unlicensed devices, there was a lot of concern about how do you actually mix that with the discussion on unlicensed spectrum. And I think between last year and this year, we've come a long way with how that whole spectrum conversation is advancing and possibly something that we'll revisit in some way as we look at the devices. Last year, we also know that it was very difficult to identify minority entrepreneurs as well as innovators that were taking advantage of unlicensed devices. And as we look around this room at the iPads and we know about the burgeoning markets of Kindles and other devices, those areas we found when we polled a small survey of minority entrepreneurs are not being taken advantage of, whether on the economic production side or the development side or on the benefit side of communities of color. So our committee last year spent a lot of time doing a couple things. One, educating ourselves on this whole conversation, talking with the FCC engineering staff, sharing it with our fellow members here as to where we were going, and polling minority entrepreneurs just to see if we were correct about our assumptions with regards to this ecosystem, and we were. More work needs to be done, and there's an opportunity, I think, to advance and include more people on this side of the debate, provided we at this committee level are able to figure out deliberately how we get more people of color engaged and involved. The committee as it stands, and like I said at the end of my commercial, we're looking for volunteers. There are only a few of us, and predominantly most of those people are very techie, so we will take the non-tech people as well. Donna Epps, Jose Marquez, Bridget Daniel, who actually at one point just kind of came on our committee. She was in India as an Eisenhower Fellow and then found this to be very interesting, so joined several of our calls after looking at some international models, and Eric Broyle. So for those committee members that are here, thank you for your continued service, but we obviously would like to add more folks who are not as intimidated by this topic this year. This committee came with no easy task. There is no data. There is, again, a very little awareness about the use of these devices. Much of what we know is around the consumption side and not on the production side. So there's not much that we were working with. And what we did in last year was to come with a charge to say from Tom, how can we take advantage of this? How can people of color benefit? How can they make money from this? And in some cases, can communities actually benefit, whether it's through innovative educational projects or healthcare projects? What does it look like? After that discussion, I think we came to, Mr. Chairman, just two recommendations that we hope to pursue this year. One is a workshop. Now, I know all of us cringe at the sound of a workshop, but we need it because we have very little evidence and data to actually substantiate the use of these devices outside of a regular pattern of consumption. So our hope is this year to put the pedal to the metal and to actually work with Tom Reed to ensure that we get a workshop that engages both the public and private sector, minority and non-minority entrepreneurs to have this discussion around the use of unlicensed devices and to make the case for some of the missed opportunities that are potentially out there that we're not capitalizing on in communities of color and among entrepreneurs of color. So that was one area that I think we want to pursue and make sure that we put a date to that particular workshop, because at the time when we made that recommendation, I think we were all being rechartered for the committee. So our hope is to move forward with that. The other thing that came out of our committee that was just really interesting, and it's sort of the work that I'm in now, is this understanding, and I think Bridget brought this up, this mentoring between the public and private sector who has managed to capitalize on this market and doing more matching among entrepreneurs that are trying to break into this market, trying to understand barriers to capital, barriers to engineering, insight and expertise with those that have made a really great killing in terms of their engagement, the Amazons and others that are really doing well in this marketplace, to see if there's some possibility of formalizing something else that will take people to the next level. And I think that's an important piece that will probably continue dialogue. We've tried to engage as many stakeholders as possible, but this year figure out how we get the private sector to maybe engage in that conversation as we think creatively. And I just want to close by saying, outside of those two suggestions and the work that we're actually going to do with regards to that workshop, last year, again, and I just want to stress this, it wasn't an area that I think many of us understood. And I just recently read something that was part of a testimony, I think, of a Comcast executive who mentioned the use of unlicensed spectrum and devices during the Boston Marathon, the tragedy around there, and how it was so important for us to look at this space because of the fact that the other communications protocol or the real-time engagement wasn't there. And you know, I work in the cable industry, represent the cable industry, to see many of our players actually come together around this issue. I think it's something that's very promising this year, more so than anything else, because it doesn't segregate this issue to just one part of the industry, but makes it more whole and inclusive. So we're just excited about looking at all of those moving landscapes and to determine what can we actually do in our subcommittee that makes real, tangible results. And I think it was glad to hear Tom say, get to work, folks, because at the end of the day, this is going to be a marketplace that will either bypass entrepreneurs of color or they'll be actively engaged and included. And so I look forward to the work of the committee. I will smile a little wider. We need volunteers for our committee who are willing to kind of jump in, even if you do not know this space, to get educated. We're very fortunate to have the FCC chief engineer have a call with us to talk us through the technology and the compliance certifications, et cetera. But would love to see one or two raise of hands to actually join our committee this year.
Thank you, Nicole.
Good.
Steve.
Well, Nicole, since you've been kicking me under the table this whole time, I'll certainly volunteer.
And I think Andy, I saw her hand raised.
Rudy?
Andy.
And I was going to actually volunteer, but she forced my hand.
Okay.
My leg is not that long.
But in all seriousness, though, I think the reference to Tom Nagel's testimony is actually the reason I would volunteer. I mean, it's pretty clear to us, at least at Comcast, that this is a space that is actually very underdeveloped, but yet there's a role that the private sector can play in deploying these type of resources. While we use it primarily for it to enhance the current broadband offering that we currently provide, during times of national emergencies, we think it's very important to at least provide that additional bandwidth. Boston is one of the examples, and there's been others as well. But we think this is an area where there's a good place for us to work together on that. So thanks.
Excellent. Any questions of Nicole? No? All right. We're going to go a little out of order because our guest, one of our guest speakers, Ruth Ann Deutsch, has got to be off soon. So we're going to postpone David's report. He's going to be part of this report on Fisher. I wanted you all to be aware of this case. It's a significant case in the civil rights area. It's a case about education as opposed to telecommunications. David's part in this presentation is going to be to bring this home to the communications industry. So I thought you all should know about this case, and Ruth Ann, who is a senior counsel at Aiken Gump and worked with MMTC to write one of the briefs involved in this case, has agreed to brief you all about it. So we're very pleased you're here to join us, Ruth Ann, and the floor is yours. Thanks so much.
Count to 5. Okay. Thank you very much for inviting me. It's a real privilege and an honor to talk with you. And as you said, Chairman, I was the counsel of record on the brief that we prepared with MMTC, and there was a bipartisan group of former commissioners who signed the brief and one former general counsel. And this case is really about the constitutional rules of the game in affirmative action programs. It's specifically about education. It could have broader reach. And it asks, what are the legitimate means to satisfy the compelling government interest in diversity of viewpoints and remedying past discrimination versus impermissible or unconstitutional racial balancing. And it asks this question at a time where the Supreme Court is as hostile as it's ever been to affirmative action programs. With the changing composition of the court, things have gotten not better. It's the only case from October. It was argued in October. It's the only case from October that hasn't been decided yet by the court, so it suggests that they are struggling with it. Justice Kagan is actually recused from the case. So the Supreme Court has 9 members. There are only 8 justices that will be deciding this case. If they were going to be split, we would have known that. That would have happened early. So there's going to be a majority opinion and a dissent for sure based on argument. So what I'd like to do is first give a little background on Supreme Court precedent in the area of affirmative action in education, and also broadcast and government preferences, so we can sort of situate Fisher within the doctrine. Then talk about the case itself, the facts of the case itself, and how it presented itself to the court within this trajectory of evolving doctrine. Then talk about the issues that came up in the briefing and during argument, especially, and sort of some of the predictions on outcome. And finally, to segue a little into what David is going to talk much more in depth about the implications for the Section 257, the work of this committee, the work of the commission. So in terms of the background, the Supreme Court case is on diversity in higher education, and there's one recent case that dealt with K through 12. The touchstone, what's been called the touchstone of constitutional analysis of race-conscious admission policies, was actually a 1978 opinion called Regents of University of California versus Bakke. And in that case, they struck down a program at the medical school of UC Davis, which had a numerical set aside of 16 of the 100 seats in the medical school at the university for members of minority groups. So that's the first of the themes that you're going to see in these opinions. They don't like numbers. Mechanical quotas, no. But that opinion was offered, the majority was authored by Justice Powell, and he also authored a plurality concurrence that wasn't joined by 4 other members, but sort of set the dialogue and actually was what colleges and universities worked with going forward, where he said there was a compelling interest in having a diverse student body in higher education to break down racial barriers, to have a diversity of viewpoints, to build an effective leadership, and that although you couldn't have a quota, it was a legitimate interest that if it had been pursued in a non-mechanical means would have been okay. So colleges, institutions of higher ed, graduate schools, law schools worked on that premise, and about 25 years later, 25 years later, 2 cases came to the court from the University of Michigan where they fleshed out what Justice Powell had really, or what at that time they believed Justice Powell allowed and did not allow in his concurrence. So the two cases, one is Grutter versus Bollinger, that came from the law school, and the second is Gratz versus Bollinger, and that came from the undergraduate. And one was okay, and one wasn't. And again, it was about mechanical use of numbers versus individualized holistic assessments. In Grutter, which was the law school case, they affirmed the law school's admissions policies, where it was a race-conscious policy where race was considered as one of many factors on an individualized assessment of the various applicants to the law school. Now, tellingly, this opinion was authored by who? Justice O'Connor. Guess what? She's not on the court anymore. And guess what? This was a 5-4 decision. So guess who replaced Justice O'Connor? Justice Alito. Not someone that you would expect to take the same side. So this doesn't bode well going forward. One of the things that Justice O'Connor, when she was on the court, played the role that Justice Kennedy plays today a little bit. She was often in the middle and often trying to weigh competing inferences and give a little here, take a little there. So one of the things that she said that the more liberal members of the court did not agree with, and so she wrote, not for everyone in the majority when she said this, was that, in 25 years we shouldn't need programs like this. And she kind of pulled a number out of the sky, frankly. I don't think there was anything necessarily in the briefing supporting that, but I think it was her own internal sense of justice, and that's the kind of judge that she was. She really was trying to get at the right result in her view and a very give or take. So Justice Ginsburg and Justice Breyer, who were the only 2 liberal justices then on the court that are still now on the court, Justice Souter and Justice Stevens also joined that opinion. They're gone. They've been replaced by Justices Sotomayor and Kagan. But they stepped back from this idea that 25 years would be enough to handle things. And the dissent, there were various dissents. Justice Kennedy wrote a pretty strong dissent, and in his view, he agreed that there was a compelling interest in diversity, which is important. But he said that it didn't pass the constitutional test, which is strict scrutiny, and a compelling interest for strict scrutiny, the affirmative action or race-conscious measure has to be necessary to further the compelling interest, and it has to be narrowly tailored. You really have to show that nothing else would work, and in showing that, you have to consider race-neutral alternatives. So race is, in Justice Kennedy's words in his dissent, it really has to be a last resort. So that's the backdrop in higher education. There was then a case decided with almost the court we have now. Roberts was there, Alito was there, Kagan and Sotomayor had not yet joined, but the political composition of the court was the same as we have now, and that was in 2007. That was a case called Parents Involved in Community Schools versus Seattle School District Number 1. So that case struck down a program where race was considered by 2 local school boards as a way of trying to achieve more diversity and integration in local school districts. And it was interesting because they disavowed any goal in remediating past discrimination, and that might have changed the analysis in that case. It was only about viewpoint diversity in K through 12. And again, this was a case, Justice Kennedy was the swing vote, struck down 5-4, and they said it was not narrowly tailored, and race was used too mechanically. This is a case where Chief Justice Roberts had his famous phrase that the only way to stop discrimination on the basis of race is to stop discriminating on the basis of race. So just a little personal aside, I clerked for Justice Ginsburg in 2008, so joined right after this case was decided, because it was one of the last, I think it was the last decision that issued in 2007, and the opinion is hundreds of pages long, and Justice Breyer has an incredibly long dissent, and the clerks, at least, I mean, the justices were pretty much already traveling for the summer, but the clerks were incredibly polarized that year. It was a decision that generated a lot of tension, a lot of animosity, deep divides within the institution, at least on the clerk level. But the upshot of this backdrop is that viewpoint diversity in education is a compelling interest. And so that survived, but attempts at quantification or rigid formulaic goals at achieving that are very constitutionally risky. And then, as I'll talk about a little bit more when we go over the argument in Fisher, there's lots of inherent contradictions and problems that arise from this approach, because it's a little bit wanting to have your cake and eat it too, and having targets but not being able to measure them, and so it creates some issues. Just you guys know Metro Broadcasting and Adirond, but just as a quick, Metro Broadcasting applied intermediate scrutiny to an equal protection challenge of FCC programs designed to benefit minority groups. So that decision has been overturned, at least in terms of the level of scrutiny. In Metro Broadcasting, intermediate scrutiny applied to viewpoint diversity in media. Now it hasn't come up again, but if the court, I think, were to get it, my guess is, and we argued for this in the amicus brief, that the compelling interest of viewpoint diversity would survive in media as it has in education, but that a strict scrutiny standard would be applied to it. And then in Adirond, that's the case that overturned the intermediate scrutiny and said that, in general, racial classifications imposed by the federal government are analyzed under a strict scrutiny standard. And in terms of the Adirond studies that the commission does, the test for any race-conscious government program going forward is whether there's a strong basis in evidence for the government's conclusion that remedial action is necessary. And so I think nothing in this precedent sort of undermines the need for evidence. In fact, it strengthens it. And as you'll see in terms of the debate during Fisher, it can pose some traps as well, because to the extent that you use numbers and targets, then you're accused of being mechanical. So it gets tricky. Fisher came out of Abigail Fisher is a white student that was rejected by the University of Texas. The University of Texas to their undergraduate program. The University of Texas has, I would say, an infamous history of racial discrimination, and after Bakke, but before Grutter was decided, actually began a race-conscious admissions policy that was struck down by a lower court of appeals. The Supreme Court hadn't yet ruled in Grutter, and Justice Powell's concurrence was just that. It wasn't binding precedent. So when that happened, the state legislatures came up with an alternative that was a race-neutral alternative. They came up with what's called the Top 10% plan, where the top 10% of graduates in high schools in Texas automatically are accepted to the University of Texas. So that top 10% plan fills about 85% of the slots in the university and was successful, but not as successful as the university wanted in increasing the representation of underrepresented minorities. And it was particularly not successful in obtaining the kind of diversity within diversity that they were looking for, so that not every minority came from, a low-income background and was, in inner city school and, in the words at oral argument that the Solicitor General ruled, you could have, a Hispanic, classics major and black, elite musician and a white top athlete, that people didn't have to fit the stereotypes associated with their groups. So the current plan was implemented after Grutter, and it hewed incredibly closely to the instructions in Grutter as well as the admonitions in Justice Kennedy's dissent. It's a very individualized, holistic assessment of student applicants where race, in the words of the district court, it was affirmed by both the district court and the lower court of appeals before the Supreme Court granted cert. And race is a factor of a factor of a factor. There's a composite score that's put together. It is not outcome determinative. The admissions counselors receive training, but when you're looking at a person and you're looking at what they've done, you're allowed to look at their race. That's basically what the plan is. Supreme Court granted cert, and everybody freaked out because it was basically like, if any plan, follows Grutter, this is it. They're only granting to either strike down Grutter or gut it, as Sotomayor said during argument. And as I mentioned, there's only 8 people deciding the case. So, and they knew that when cert was granted. I think Justice Kagan, recused herself right afterwards, or might have even been recused from the cert process. So something's cooking. Some of the interesting issues in the case and things to pay attention to. The Abigail Fisher and her lawyers, they said from the outset, it's there in their question presented. They reiterated it during oral argument before the court. They do not want to overrule Grutter. So they are basically saying this program doesn't satisfy strict scrutiny. They're not trying to completely throw out the court's recognition of a compelling interest in diversity. Both sides agree there's a compelling interest. But the issues arise when they say, well, how do you say it's a necessary goal, and how do you show that the program is achieving that goal? And Justice Scalia, during argument, because the university said, we're pursuing this goal because we want to reach a critical mass so that people don't feel isolated, so that minorities are not monolithic, so that there's viewpoint diversity, so that we're creating the kind of leadership in a multicultural, multi-ethnic state like Texas that can lead and succeed and inspire. And the other side said, you're looking at demographics, you're trying to track demographics. And there was a lot of back and forth during our oral argument where at one point Justice Scalia said, well, what is critical mass? It's like grabbing a cloud. You're not, and there was absolute refusal on the part of the Solicitor General and the university's lawyer to put any numbers, or to even say with 2 exactly similar applicants that race would be dispositive in any given case, because of the way the holistic works. It depends, are they similar oboe players or are they similar athletes? And if the university needs an oboe player and not an athlete, race may or may, so the way admissions work, they couldn't answer those questions, but the justices were frustrated. I think that Justice Sotomayor probably got it right when she said that you may not be asking us to overrule Grutter, but you are asking us to gut it. And my guess on reading the transcript and the fact that they granted it all is that we're going to get a decision striking down the program authored by Justice Kennedy, who's the swing vote again, that will leave a very, very, very tiny window open for considering race. But, it's hard to know how it can be any tinier than what they already did. So I'm not very good at predictions, but I'm not optimistic about the result, I guess, is the general prediction. In terms of implication for the work here, I think that more evidence is always good and always persuasive, and knowledge is power in this area, particularly because the agency and the committee have, more than one compelling interest to serve. It's not only viewpoint diversity. You have a statutory mandate to remedy past discrimination, and the court has treated the remedial cases differently. And there's work to be done and value to be had in building a record. And even building a record and an analysis to show the extent to which race-neutral measures can serve race-conscious objectives. Because I think, the top 10 plan did not get all the way there, but it did do something, and focuses on socioeconomic background and regional diversity and other non-constitutionally suspect categories can do a lot of the work and get you a lot of way down the road that race-conscious measures might, raise flags. In Adirond and then in Grutter, the court insisted that strict scrutiny is not strict in theory but fatal in fact. But I'm wondering, whether with the current court that adage is still the case. But the good news is the compelling interest, I think, is going to survive, and I don't think there's any doubt that interest is present multifold in media, because not only are you talking amongst yourself, you're talking to us, and you're creating an informed citizenry, and you're the way that we speak to each other and learn about each other. And we made that argument in our brief, and I'm sure David has more to say about it. But I salute your work, and I wish you all the best. Thank you.
Thank you, Ruth Ann. David, can I go ahead with David, and then we'll open it up for questions? Thanks, Rudy.
So I'd like to address how what the court is about to do could impact particularly the question of diversity in the media. It's not immediately something you think of, because we usually think, when we think of diversity in the media, we think of it as a close cousin to diversity in education. But it's more than that. One of the issues that was presented in this brief that Ruth Ann held the pen on with MMTC and the former commissioners and Chris Wright was the fact that, like other industries, the media benefits greatly in terms of innovation, diversity, and competition, to the extent that it is able to attract and employ people who have been exposed while they were in college and professional school to a diverse learning environment. The way we put it, I'm going to quote briefly from this brief: the promotion of diversity in higher education is essential to the promotion of diversity in the mass media because the nation's colleges and universities are the pipeline for opportunity in the mass media and the trainers of future media programmers and journalists. Diversity in higher education allows not only for a robust exchange of ideas on campus, it is an essential predicate for ensuring a robust exchange of ideas in communication through mass media. For those trained in journalism or communications, an environment that alerts them to the continued existence of racial bias and stereotypes and affords them the opportunity by living example to dispel such biases is doubly important. And journalists, programmers, and media owners of all races who have been educated in a diverse and culturally sensitive environment will be better able to avoid unconscious racial biases and to more effectively communicate in a way that fosters understanding across racial and ethnic divides rather than exacerbating such divisions. Now, the other way that this decision could impact what we do derives from the fact that the law on diversity in the media, in fact, flowed from and was very much informed by the law on diversity in education. When we think of the Metro Broadcasting case, it quoted very extensively from some of the education cases, because in many ways, after you graduate from school, the way that you become exposed to diversity in the workplace really is kind of the successor to your exposure to it in school. And much the same happens in the sense that it is a crucible of discussion and learning. So what could happen in this decision? There are about 3 or so possible outcomes, and this is somewhat of an oversimplification. One is that maybe the program in Texas is thrown out, but the fact that diversity in education is a compelling government interest is retained, in which case the impact on the media industry would probably be that it would be harder for universities to diversify themselves and thus feed people who have been exposed to that into this industry, and that would be unfortunate. Second, the court could hold that diversity in education is not a compelling government interest anymore. It could reverse that part of Grutter, notwithstanding that Ms. Fisher didn't ask them to do that. It could happen. Were that to happen, the court could do it in one of two ways. It could say it could look at the question of diversity in education just by itself and not say anything about diversity in the media. Maybe there'd be a footnote or some dictum suggesting that, well, we don't have a record on that. Maybe it survives, but diversity in education doesn't survive. That's for another case. You can almost imagine that one of the opinions will almost be read as inviting the bringing of such a case, which would have much the same outcome as this case does. And the other way the court could conceivably handle it is to just say diversity, whether in any context, is not a compelling government interest anymore. I think that's unlikely, but it's theoretically possible, and there certainly are at least 2 justices who clearly, or maybe 3, who seem to have that view. Now, what would that mean in terms of what happens with the current state of the Commission's consideration of proposals to advance diversity? Well, one predicate for proposals that could be race conscious is that after parents involved, if the only way to achieve diversity is through race conscious measures, such measures have to be a last resort. The Commission has to have tried race-neutral methods first, and certainly no one can say the Commission has tried all of them yet. But if it were to reach that point, it would need to have before it what are called Adirond studies, which look at what are the disparities, how did we get these disparities, what was their cause, what was the history, and why this interest is compelling, and why the methods being considered are narrowly tailored. Those studies have been done by the Commission before. They were produced and released in this room on December 12, 2000, when Bill Kennard was chair. There were 5 such studies. They cost over $2 million to do, And they have unfortunately, and they were superb, they have unfortunately sat on the shelf ever since. The data used for those studies came from the years 1996 to 1999, so it is long since stale, and except for the historical study, were it to be done again, it would have to be started over. So one might ask, well, my goodness, if we're not going to be able to use race-conscious methods at all, one potential outcome of this decision, would it still be desirable to do these Adirond studies? Well, to some extent, yes, because it's always good to kind of remember that data-driven policy making is desirable irrespective of whether it's also necessary to meet a constitutional test. So my answer to that would be that the Commission, irrespective of the result of this case, should continue to press forward in trying to get those studies done, at least to the extent that they're useful in fashioning the kinds of remedies, whether they're race neutral or potentially race conscious, that could result in preserving and expanding diversity in the media or in other industries. That's it.
Thank you. All right, I'm going to throw it open for questions. Rudy, you have the first question.
Answered that question. I have several questions, but I'll just ask the first threshold question. David answered it partly. I was trying to get a sense of, at least within the jurisprudence, the overlap between, the race-conscious measures you mentioned and the goal of achieving diversity. To what extent the court recognizes that that is still, in fact, a goal to be reached, and within that, race-conscious methods may be one of many particular aspects. To what extent is there an overlap between the two, or are we talking about where there can be a decision purely on the race-conscious methods, not necessarily on the achievement of diversity as a goal?
The validity of viewpoint diversity as a goal in higher education, I don't think is seriously being challenged by Fisher in this case. David suggested maybe the court would reach out and say, well, that's not a legitimate goal. I don't think they're going to go that far. But the court does distinguish, because I think the issue is you have a goal, but you don't have a means to measure it, because they basically back themselves into a corner where they, from 1978 with quota, in Bakke not wanting quotas to up through parents involved, and so it makes it very difficult to show that you are crafting a program that's narrowly tailored to meet a goal when the goal cannot be based on something that you measure.
Nicole.
So I have a question, and I think this is actually a really good overview for the committee, and I'm very much aware as an MMTC board member of some of the precedents behind paralleling what will happen in this case to the media industry. I guess my question is, though, much of that legal framework was also designed for a traditional structure. So the educational system has a legacy of being very traditional, whereas what we're seeing today in the media and communications industry is a lot more fluid, right? And so I guess the question I have for you, even though this is something that we actually want to monitor and see how it's correlated with media diversity, are there other cases, precedents, that we should really be paying attention to that will ultimately impact media diversity with these new boundaries? And David, I know you've been watching this, but it's something to think about. I mean, the journalism field is under attack. Digital is still an uncharted territory when it comes to diversity. So just curious, are we thinking forward with regards to other legal frameworks that we should be looking at?
Off the top of my head, I think there are First Amendment and other issues that come up, but in terms of racially suspect, constitutionally racially suspect cases, I haven't seen any that deal with the more cutting edge media. And in fact, it sort of makes sense, because you don't have one decision maker that you can say you are doing something where you're using race in an inappropriate way to allocate a scarce resource, whether it's admission to the university or entitlement to government program. And I mean, Adirond is a case in Metro Broadcasting where you have a finite government good that's being allocated, and I guess the commission, still does stuff like that, so it's going to come up, but there haven't been recent cases.
Been very careful in the way it's proceeded in this area. One has to keep in mind what I think, and Ruth Ann, help me make sure I have this right. There's one change in the law that we often overlook that it came from parents involved in 2007. In 1989, there was a case called J. Croson versus City of Richmond, in which Justice O'Connor wrote the opinion, and she basically said that a government, before it could undertake a race-conscious measure, would be expected to undertake most, not all that the human mind can come up with, but most race-neutral measures first, and be able reasonably to say, well, it's unlikely that we're going to solve this problem without a race-conscious measure. Parents involved tightened that somewhat, actually quite a bit. If you read Justice Kennedy's opinion, it was clear that he wants government actors to basically exhaust essentially all potential race-neutral measures in good faith, in the hope that maybe they will work, and then only turn to race-conscious measures as a last resort. It's very, in many agencies and cabinet departments that use, for example, a socially disadvantaged business definition, which may be regarded as race-conscious in some instances, they've already tried a vast number of, and probably enough to satisfy parents, race-neutral steps. The FCC is a little behind them, however, because it has not come up with a race-neutral eligible entity definition, which is effective. It has not considered quite a number of race-neutral proposals, but it has them under consideration. So it's maybe a couple years behind where other agencies are. What would happen if the court calls into question in some way whether diversity in the media is a compelling governmental interest, the commission would still need to try, in good faith, just as it is now, to consider race-neutral measures and see if they can be made to work. Certainly one of the proposals that came out of actually a predecessor of this diversity committee in 1990, when the commission had its minority ownership advisory committee, came from Jim Winston at NABOB, who was a member of that committee at that time, as he is now. And that is that the commission ought to, in the normal course, whenever it takes a major rulemaking decision or considers a major merger that could have implications across the board, look at, just as it does with the OMB showing that it has to make, the RFAs, look at consciously examine the impact of that decision on minorities and women and on diversity, so that there aren't unintended consequences that are adverse. And on that affects a great deal of what the commission does that may on its face, on the surface of it, seem not to have anything directly to do with race and gender, but nonetheless has those consequences. That proposal, which has been endorsed by over 50 organizations, is still pending, and Jim, I hope before you retire that the commission will grant it.
Other questions? Other questions? Well, yes.
Mr. Chair, I just wanted to thank both Ruth Ann and David. I've read a lot of synopsis of these cases, and being a lawyer, I guess I always have that crazy desire to look at interesting cases. But I will tell you, your synopsis on where we are, how we've gotten to where we are today, has been excellent on both of your cases. And I know it takes a lot of time to do this, so thank you, because I don't think we're paying them anything, Mr. Chair. For no, good.
About as much as we're paying you.
Yeah, that's right. Well, they're broke then. But I hope that this case is very, very important, and particularly as it impacts upon media. I hope that, Mr. Chair, if the decision comes out before our next meeting, that maybe we'll have a called meeting so that we can all be informed for our constituency, because I think this is very, and will have a very long-term impact upon what we do here today.
Yeah, that was my feeling exactly, and we will try to get the word out, and hopefully we can ask you to come back if once the decision's out. Thank you. Eric.
This is, I guess, for Ruth Ann and for David. In thinking about O'Connor's comment about 25 years from now, let's call it change jurisprudence, right? I know you said you don't like to hazard guesses on things, but what if the justices in this case, or maybe if not in this case, the next case, took a line of that thinking and said, you know what, because technology is such that, you have YouTube, right, that doesn't cost, there's no barrier to entry with a YouTube video clip. And because of technological changes, but then the other piece of it, though, would be the demographic shift, right? If you would take a guess, is something like that going to come up? And would you think something like that might? No, not a term. They're saying we don't need to take that. It's not a compelling interest anymore, right? Because you have technological changes and you have demographic shifts.
So diversity is no longer a compelling interest.
Right. I would think that the demographic shift would point the other direction. I mean, that's certainly the argument that Texas made, that the demographics of the state were changing incredibly, and the flagship elite university was not mirroring that demographic shift. So I think you're asking two separate questions, right? Because again, for something like a scarce license to part of the spectrum, or entry into an elite higher education institution where you have scarce resources and where they're not being allocated in accord with the underlying demographic, I think there is still going to be a compelling interest. If it's a non-scarce resource like being able to post to YouTube, I think although there are studies that talk about access to broadband and access to wireless technology and things like that, so not everybody can post to YouTube.
But what if the justices say, I hear you on if there are fewer people, what if the justices say you can protect yourself with the vote now? If you think about somebody like John Hart Ely's, right, political process theory, right, at the whims of the majority, you have
right, and in fact, it was the state legislature in Texas that passed the top 10. I mean, the justices are perfectly capable of saying, it's not necessary to do anything; things will fix themselves. If that's what you're asking, I don't think they're going to go that far, but I might be wrong.
David.
It's important to remember that there is actually another case in the Supreme Court this term that addresses this question that you posed, which is basically, are we now where Justice O'Connor thinks we'll be in 2028? Have we reached the promised land? Is there any further need because this problem of race has been solved? And that case is Shelby County, Alabama versus Holder, which challenges the constitutionality of Section 5 of the Voting Rights Act. And the principal theory on which Shelby County is proceeding is that, in fact, we elected an African-American president. Voting rights violations are, in their view, rare, although that's a matter of degree, and there's a factual record to the contrary. And one of the justices at oral argument made a statement in which, frankly, if you were there, people gasped that, well, even though there was a 98-0 vote to continue this provision just a few years ago in 2006 in the Senate. This justice said, well, it's hard to get people to vote against a racial entitlement. So it is quite possible that, at least in dictum in that case, and possibly in this one, that question may be addressed, if not completely answered.
And just another note from a different oral argument in the DOMA case. At one point, one of the advocates said, well, why do we even have to do anything, because, the gays are so politically active and you're going to fix things on your own. You're not really a disenfranchised political group. So, yeah, there's definitely that willingness at least to go off at oral argument. Whether they can transfer that into a written opinion that has to be based in precedent and conform, at least in form, to their role as judges is another question.
All right, please join me in thanking Ruth Ann and David for that great presentation. Appreciate it. Thank you.
I'm sorry.
So more on this case as it develops and we get a decision, and we'll keep you informed about this for sure. David, do you have a report from your task force?
Yes. Thank you. I first want to recognize the members of the EEO working group who worked last year on the issue that we were assigned, which was to examine the feasibility of a study and statistics, which would develop statistics on best practices on FCC-regulated and ancillary industries on recruitment, training, and promotion of minorities and women. The members of the working group were Andy Schwartzman, Jason Legria and Karen Narasaki, Jessica Gonzalez, Carla Ballard, Rudy Brioche, and Sylvia Strobel, and thank you very much for your work on this project. We did, in fact, prepare a comprehensive proposal and estimate for conducting such a study and costed it out. Unfortunately, it presently appears that there aren't the funds to conduct that study, but it's waiting for maybe the sequester to lift, and perhaps it can be done. In the course of our work looking at those questions, a number of ancillary issues arose that perhaps it would be desirable for us to consider this year. One of those is looking at the FCC's current regulatory program and the extent to which it recognizes best practices. And as the Commission has said, really since it adopted equal employment rules in 1968, it hopes that companies will do more than the bare minimum in order to develop genuine diversity in these industries. So the question then was, is the audit program that the Commission now has working? Does it produce diversity? The second big question that came up was whether we need more granular data. This is the so-called Form 395 question, which has been pending since 2002, whether to have a snapshot or photograph of who's employed. The reason that this came up was because the purpose of the current equal employment rules is not so much to promote diversity as to prevent discrimination. That's what the Commission has said when it reinstated some of those rules after a couple of court cases in 1998 and 2001 that cut them back. And the Commission does have a long line of precedent saying that it is inherently discriminatory if a company recruits primarily by word of mouth from a homogeneous staff. And if you think about that, there are some elements of that. If you recruit by word of mouth but you don't have a homogeneous staff, that may be inefficient, but it's not discriminatory. If you have a homogeneous staff but you recruit by a number of means, that's not discriminatory, that's desirable. But it's only when those two things occur together that the EEOC and the courts and the Commission have said that it's inherently discriminatory. And because it tends to replicate the current status of the staff being homogeneous. So how do you know? We know now whether recruitment is done largely by word of mouth, because that's what the audits look at and that's what the renewal applications, the EEO programs, have to show. But we don't know the other half of that equation, which is whether the staff is homogeneous. So the question that might be looked at is, well, maybe there's a way to know that's tailored to address that question of whether there's discrimination. We also looked at the question of what about the fact that particularly the broadcast industry in some respects may be shrinking in some ways. The EEO obligations of stations have typically tended to focus more on recruitment than on what happens when people do become employed. In 2004, the Diversity Committee looked at it, came out with a recommendation that those obligations be restructured to focus more on mentoring, on training, on promotion, on retention, than on just recruitment. Those recommendations remain pending, and perhaps now that the industry has evolved somewhat more, it may be a good time to look at that again. And finally, the question of whether the equal employment obligations and a related one that Congress imposed on cable in 1993, the cable procurement rule, looking at how MBEs and women-owned businesses have an opportunity to get contracting work at cable systems. That has to be reported on. It's managed, enforcement is managed by the EEO staff. It simply has been placed there. But whether those initiatives ought to be expanded across platforms in light of the Commission's preference for platform neutrality. That is, should they be applied to wireless, to wireline, to satellite, to other industries that the Commission looks at? And what about information industries, those regulated under Title I? It's a question that the Diversity Committee considered in 2008, passed a recommendation that the Commission should extend these. There is technically a common carrier EEO rule, has been since 1976, but it's not been applied. So that's one other question that seemed to be timely in light of the fact that it hasn't been looked at in a while, yet we're gravitating more and more in the structure of the industry toward other means of distribution being available besides just broadcasting. So this may be a good time to look at those issues.
Thank you, David. Any questions of David? Yeah, Jessica.
This is perhaps not directly on point, but I think very related. I'm wondering if there's a way that this committee this year can help infuse more diversity into the FCC itself. I think that's something that we could probably help quite a bit with around the table here.
Thank you.
Hire anybody, maybe.
Whenever you're ready, we'll have lists of folks.
There you go. Binders. Be very helpful.
No, I wasn't going there.
Any other questions for David? All right. If not, I'm sorry. Go ahead, Jason.
Also, just wondering, with the Fisher decision coming probably by the next meeting, if we could somehow maybe our committee look at any ramifications from what the justices actually say in that opinion.
Sure.
I know maybe we'll have an update, but maybe.
Sure. Let's see what they say first, and then we can decide those kinds of questions. But that's one of the reasons I wanted the briefing, so we could lay some groundwork for it. But it's a good point. Thank you for raising it. Anything else? Okay, I'd like to move on to our final report. And this is, we're fortunate to have with us Phyllis Eagle Olson, who is the president and CEO of an organization called the Emma Bowen Foundation for Minority Interests in Media. And with her is Jared Hill, who is a product of that program. In the spirit of full disclosure, I have to tell you that I was vice chairman of the Emma Bowen Foundation for many years. I've had a role in getting it off the ground, and I still remain on the board. So just so you know that. Jared made me feel very old a moment ago when he told me that he was a year old when we started the Emma Bowen Foundation, and now he's a product of it. So, and with that, I'll turn it over to Phyllis. Thank you for being here.
I think I might need, just in order to be able to tie my presentation to the computer, is there somebody that can flip a switch or do whatever needs to be done?
Jeff? If you flip the switch, you just wave at me.
Okay, and there's my computer. First of all, I really appreciate the invitation to come and talk to you. Anytime I have a chance to, Thank you. I really do appreciate the opportunity to be here, and I love talking about the Emma Bowen Foundation. I think it's one of the programs that the industry as a whole can be very proud of. We have a lot of success stories, and we have tremendous support from the industry and our corporate partners and our board of directors in making this a successful program. So it's one of the few things that in listening to all of the things that everybody has angst about, it's nice to have something that we can point to and say, this actually works and we get this support from the industry. So the first thing I wanted to show you is a PSA. Part of our recruitment process is to get the word out so that students will apply to our program. And so this is a PSA that will help you just get a brief overview.
Media careers in advertising, marketing, public relations, operations, and technology. What's the one thing they all have in common? The Emma L. Bowen Foundation. Join our paid work study program. Get the competitive edge you need to make it in media. Multi-year internships, great mentors, scholarship funds. Minority high school students, college students. Do you have what it takes? Log on to emmabowenfoundation.com and find out.
So that's a PSA that runs. We also have one that's in Spanish that runs as well throughout the country. So, and if you'll just give me a second, I've got a little bit of a PowerPoint presentation here, and so there we go. Okay. Our mission of the foundation is to recruit and develop a pipeline of diverse talent for the media industry. And as Henry mentioned, we've been in existence for 24 years. Next year we'll be celebrating our 25th anniversary. It's not going. I'm going to let you do it. Get the technical expert here. There we go. Okay. So our goals for this program are to recruit the best and the brightest. We offer hands-on experience and professional development for our students. We establish high standards of excellence in job performance and academics. We create networking and mentoring opportunities which are essential for career development. We facilitate conversions to full-time employment. And we maintain ongoing affiliation with all of our graduates. Just a quick about us. We were established in '89. We currently have 39 corporate partners. We have a very engaged board of directors, which I think is a keynote for our success because it's a top-down commitment by all of our companies. We are exclusively focused on the media industry, primarily in both broadcast and cable, and we now have a tech track so that we're getting some of our vendors like Motorola and Aris have now become a part of the Emma Bowen Foundation. We currently support about 250 interns each year, and most of the interns are in at least 3, if not 4 years in the program, so it's a multi-year internship program. We have more than 600 program graduates, and we have foundation offices in D.C., New York, and L.A., all donated by our corporate partners. This is a brief look at our corporate partners. I'll leave that up for a second. The basic program elements of the Emma Bowen Foundation, it's a paid multi-year work-study program. All of our students also earn scholarship dollars matching whatever they earn in salary each year. So it really helps with paying for college educations, particularly for our students that are really terrifically bright, and this gives them an opportunity to go to a better school than they might have if they just had to rely on family resources to go to pay tuition. As I mentioned, we have a new media and technology track, matching scholarship funds. All of our students are evaluated annually by their supervisors, and they get direct feedback to help them grow professionally and develop. They have accountability for maintaining grades. They must have a 3.0 GPA to stay in the program. They have to turn in their transcripts every semester. We have an annual summer conference. which helps them to broaden their view not only of their company in particular, but then the industry on a broader basis. And that also helps with them being able to network with industry professionals and to create the network that will be established for the next generation of media executives because they get to know each other as well. We have a junior forum which allows our students to meet with recruiters across the country and of media recruiters so that they have a chance to think about what they're going to do for finding a full-time job a year before they graduate from college. We also have a career fair for our seniors that's virtually all of our corporate partners participate in for their key recruiters as well. We have a Link mentoring program, which is a very key part of our program to help students learn about working with mentors, and there are various other components of this. We do this in 2 cities every year. For about 60 of our students get involved in this program every year. We have a wide variety of resource guides, and we do a lot of broad training and professional development for both our students and our graduates. We've just recently formed an active alumni association, and we have very active and ongoing relationship with all of our graduates, and that helps in 2 ways. One, when they're getting ready to make a job change, we can hold them to the industry. We can help connect them to other sources, to HR executives and other media companies, and when media companies are looking for talent, they can come to us and we can reach out to our graduates as well. For the recruitment part of it, I won't go into this in a lot of detail. You've been sitting for a long time. Suffice it to say, we recruit locally. It's a customized recruit for every opening that we have within. So if a corporate partner says, I want to place a student in Atlanta or New York or Dallas, we custom recruit for that particular location. Each slot, we probably will give a company maybe 3 to 5 candidates. The company actually makes the final selection of the student that will stay with them throughout their time in the program. It's very competitive. I will tell you that for this year we have around 80 slots for 2013 to fill. We probably have well over 2,000 applications. So it's a very, very competitive process, which really, I think, helps us to bring the best and brightest to the industry. We do all the pre-screening and then send the final candidates for selection. While in the program, students are required to work every summer in 8 consecutive weeks for a 40-hour work week. They must attend a 4-year college or university, as I mentioned, a 3.0 GPA or better, and have to maintain it the entire time they're in the program. While they're in the program, we encourage the companies to rotate students to a variety of functional areas. So if a student goes in saying, the only thing I know about media is on air, they don't have a clue about all of the other opportunities that may exist within the company for marketing and sales, public relations, legal, HR, finance, marketing. And this gives them a chance, by having these rotations, they have a chance to sort of test drive other careers or other functional areas before they graduate from college. They can sort of course correct for school if they decide they want to go into a different area of media than they first thought they might. As I mentioned, all of the students are evaluated, and that helps give feedback so they can make minor adjustments when necessary. And all of the development pieces that we encourage our students to participate in, so they come away with a much broader understanding, more sophisticated. They have a network. And when they graduate from college, you can imagine a college graduate has 4 years of experience on their resume. They have a fabulous network of industry executives that are all there coaching them. They have the foundation at their back. It really gives them a step up compared to their counterparts that are coming out of school with just any kind of a summer job. Because they also have access to all of these recruiters, and interestingly, we just had a senior phone call a few weeks ago with all of the industry recruiters and our class of 2013 graduates, and the majority of the recruiters said, Emma Bowen on your resume is like the Good Housekeeping seal of approval. It gets to the top of the pile. So we're very happy to know that our students have that reputation coming with them as they're looking for jobs in the industry. The commitment that our corporate partners make, and I can't emphasize enough how wonderful they are, is the direct work experience, skill development, increasing levels of responsibility. Many of our students, by the time they're in their second and third year, are doing the work that they would never have a chance to do as an intern had they not had this multi-year experience of coming back. The rotations, the evaluations and developmental feedback, and probably most essential is the mentoring. I can't tell you the number of executives that sit down personally with students and talk to them and advise them, and it gives the student confidence that they can have that relationship with a senior level executive, and it helps to really guide them to navigate some of the difficulties of corporate life. The fact that our companies match and pay for the interns and help support the foundation financially as well is a huge commitment, both in time and in resources by all of our corporate partners. And we have a very high conversion rate, about between 60 and 70%, depending upon the economy in the year, of our students take jobs in the media, some with their corporate partner if the spaces and the opportunities are available, but certainly among our corporate partner family. And just to give you quick, and then I'm going to leave time for Jarrett because he has a great story, but just to give you an example of what I'm talking about, I'm going to go through a few of these. Joe Sutton, class of 2009, a news editor at CNN, and a Peabody Award winner. And I ask you to focus on their grad year versus what they're doing. Megan Aguayo is our 2012 Student of the Year. I just got a video from of a piece that she put together for marketing for Bright House yesterday, and absolutely rave reviews from the creative director from Bright House saying she is the best thing we've had here. Our clients love her. She puts together some of the best pieces. Michael Esteme is a meteorologist in Lexington, Kentucky. Michelle Redberg, a Native American student in Minneapolis, is with WCCO CBS, was just named an account executive with that station. Some of you may know the name Gio Benitez if you see any of ABC. I know Marcellus knows him personally. And he just was picked up by ABC as a national correspondent, and he just broke a new record. He's only been with them for 3 months, did 92 segments in 3 months, which was a new record for ABC. Arnell Davis just yesterday was promoted to Associate Marketing Manager at HBO, class of 2010. Adrienne Cordero has had 2 promotions with Comcast. She became manager of ad sales support with Comcast Spotlight. She hired an Emma Bowen graduate as her assistant when she was a supervisor. That assistant just got her previous job as she moved up, which was really great for us. Alejandra Fonseca, another, was hired by his corporate partner, NBC, in Miami. Neftali Rivera is with Hearst. Angela Zavallo is in government relations with Comcast in Chicago. Dominic Ricks is on air in Lynchburg, Virginia. Becky Ho has a wonderful story. She went into marketing. She's assistant manager of consumer products with Disney ABC and has had multiple promotions as well. And I won't go through. There's many of these that just really great success stories. And because I want to mention one more before I do Jarrett. Rodney Hawkins, who is down here on the bottom right, great story for him. He graduated from Howard University in 2011. He joined CBS as part of a special news associates program. He was assigned to the presidential campaign right out of the box. He was very good at his job. He's in the digital area. He was assigned to Vice President Biden and was spent probably 3 months of the end of the presidential campaign flying around on Air Force Two. When I caught him with him just recently, he was at the Vatican covering the new Pope. And if you were listening to coverage on CBS during the Boston crisis, his name was all over it because he was reporting live from Boston. And this is a young man that graduated in 2011. So, we have just wonderful opportunities for our students, and I think it's because of the commitment of the companies that help us create these opportunities. And with that, I would like to introduce you to Jarrett Hill, who will tell his story.
when you run through that list, it makes me feel like a slacker.
Not hardly.
Oh my gosh, I'm not doing anything with my life. All right. Well, my name is Jared Hill. I was with C-SPAN when I was in the program. So it's interesting. The program starts off typically with people that are going into their senior year of high school, they are seniors going to their freshman year of college. I started off going into my senior year of high school. I have a late birthday, so I was 15. Going into this, I was like, oh yeah, TV. I'm going to work for MTV or like BET. I got put at C-SPAN. In the beginning, I was like, all right. But it was an amazing opportunity because it taught me so much, not only about television, not only about government, of which I knew nothing, but about working in a professional environment, which for a 15-year-old kid is an amazing experience. And then being able to go back every summer, oftentimes also during my winter breaks because I was here too, and working and becoming a part of this team and a part of this family was experience that I would not have gotten anywhere else. While I was with C-SPAN, as Phyllis said, part of the goal is for these students to kind of move around the company. So I got a chance to work with the field crews. I worked in marketing. They have a bus that travels through the country. So I got a chance to ride on that, wrote some press releases while I was still in college, which was kind of amazing. But then one of the really interesting things was one summer I was working in the international programming department, very small department. And at that time, there was no one that spoke Spanish. I was a Spanish minor, and so I forget what was happening exactly during that summer, but for some reason, they needed someone to be able to call Latin American media markets to get information. And I was like, well, I kind of speak Spanish. They're like, oh, really? You sure? I was like, yeah, I do. And then 30 seconds later, they said, okay, great. Call the embassy. Find out what, and I was like, all right. It worked out, and I did well. I guess I didn't get fired. But that really is a testament to the trust that the companies have in the students and in the foundation, that these kids are good. They know what they're doing. You can trust them with real work and expect it to get done as if they are a real employee. Coming out of the foundation, I graduated from Morehouse College in 2010. I'm from this area, but kind of bounced around. After graduation, I moved up to New York City, where I was an NBC page. I worked there with the Today Show in publicity for one of our film company's Focus Features, and then with Saturday Night Live, giving out tickets. But the best part was that I got to go watch a show for free, which you would be surprised how few people do that. I was like, wow, all right, I'll take it and get paid for it. Great. So I did that, but then I knew that I wanted to work in journalism. So I kind of was trying to figure out my way. And a position opened up at Dateline, where I worked as the assistant to the executive producer. Also did some assistant producing and helped to manage the social networking profiles. Fantastic experience. I learned so much about television, journalism, the internet, business, running a television show, basically. But knowing that it wasn't necessarily a vein that I wanted to go in, at least not at that time. I jumped ship. And I took the leap into local news, and that's how I ended up at WMDT on the Eastern Shore. It's been a learning experience in so many ways. I kind of say that I now live in America because I've only ever lived in D.C., New York, and Atlanta. So this is an eye-opener in a lot of ways. So it's been great. I've been there for about 7 months now so far. But I'm really just here as a cheerleader for the foundation and kind of as a spokesperson and advocate for the dozens of friends that I have that are doing amazing things that start off in the program, and the hundreds of other people like me that either have or will come through it and do amazing things in the industry. I think it's the perfect thing for the media industry because it really does give minority students the opportunity to see what's out there and to realize that some of these jobs and positions are real things that real people do, and they can do them themselves as well. That's all I got.
Any questions for Jared or Phyllis? No, well, thank you again for coming and sharing the foundation with us. All right, well, that completes our agenda. Is there a new business? Mr. Roberts.
Mr. Chairman, just a couple of quick things for some of you who I've known for a long time. You know, in my former life, I was a locally elected official and served on a number of national boards, including the National Black Caucus of locally elected officials, which represents about 7,000 African American mayors and city council people, as well as I served on National League of Cities board. Just recently at their March meeting, and this is without my prompting, they passed a resolution which they have sent to the President and to Congress and governors concerning promoting job creation and economic diversification through attraction and expansion of film, television, and digital media production. They were very much aware that I serve on this committee. I did not know this was coming, but I'd like to at least pass this around. Maybe the staff can get it to the members who are not here so that they can understand that we do have support out there in these local communities. I think I'm sitting on my phone is what happened. And so I'd like to pass this around because I was asked to at least present it to this task force. And then secondly, we are very concerned, those of us who are broadcasters, about the consolidation of the industry. Particularly, we're concerned with this recent announcement with Sinclair. We just see that, again, more of the fewer voices of diversity are occurring out with the acquisition of TV stations by large groups. Very, very few small group owners will be existing in the years to come if we, as not only this task force but as a commission, should really look into these issues. Thank you, Mr. Chair.
Thank you, Steve. I'm wondering if thanks, Bill. I'm wondering if you could visit with, Tom Reed about these issues that you've tabled here to see if there's any way we can do anything about any of these issues, and if so, what that might be. So if you can find a mutually convenient time to do that in person or by phone, I think that would be helpful.
Yeah,
but thank you for raising these important issues with us.
Good, thank you.
Mm-hmm.
And I'll distribute this to the rest of the group.
Good, thank you, Barbara.
Sherman.
Thank you, Mr. Chairman. This question is more posed to you and to Tom around this. There's been a lot of attention focused on this whole issue of foreign ownership as a tool to help increase minority ownership. I only know what I've been reading in the trade press, particularly over the past maybe 3 or 4 months. But that particular Coalition for Broadcast Investment, I think that's the name of the organization, that's been touting the whole issue about, foreign investment in it. But one of the things that they've been very consistent in saying that could also be a tool by which they can help increase the number of minority ownership, the number of minority owners. So my question is what role will the committee play in this whole area, and if there is a role that we will play, and just kind of get some feedback and direction on how we may or may not be involved in that process. And I've certainly heard people like Commissioner Pai talked about how he is supportive of that area to a certain extent. I don't want to speak for him, but he and I were having a conversation. So there's there seems to be quite a bit of buzz and dialogue about that whole area, and I wanted to see is there a role that we will play or should play or won't play in that whole area.
Yeah, the committee. I'm sorry.
There's actually that issue is before the commission, and it has been put out for public comment. So right now, I don't know what the timing is on receipt of those comments, but someone, I forget the name of the group, filed a request that we consider modifying our rules with respect to foreign ownership in the broadcast area. It presents a lot of interesting issues, controversial issues. So right now, it's in the early stages because the public has been given the opportunity to file comments.
Well, my thought is that even early stage, maybe that's an opportunity for us to get our arms around it and see if there's a role that we can play around where that issue goes.
Well, we can certainly think about that, but as of this point, the commission has not asked for this committee's input on that, and we can certainly think about that and work with Tom, and I would invite you to have a conversation with Tom about this and whether to see if it's a possibility. It sounds like it's a little late in the game in terms of this horse may have already left the barn. I just don't know, but it's an important issue. I think it involves minorities, and it's something that we might legitimately take up. But as of this time, we don't have any mandate to do that. Doesn't mean we couldn't have one at some point, but again, it may be a little late in the game. But talk to Tom about it. I think that would be the best thing to do for you. Yeah. Yes, Jim?
One more issue that I just want to at least put on the table here, because we've talked a lot about and Tom, I'll be following up with you. But we've talked a lot about the decline of diversity in broadcasting, and obviously it's an issue that I spend a lot of time thinking about. I've been trying to figure out ways of addressing the continuing decline of minority ownership. And I read a Congressional Research Service report that came out last year that stated that the federal government spent in fiscal year 2011 $750 million in commercial advertising, where the federal government is actually an advertiser. A little over half of that comes from the Department of Defense, but Treasury, Transportation, Homeland Security, and HHS all spend $30 to $50 million each. And it dawned upon me, well, the Federal Communications Commission at least is a part of the federal government, even if it's not a executive branch. And I know that there's a great deal of conversation within federal agencies. And it just occurred to me that perhaps there is a avenue of communication that the FCC can help open that would help minority broadcasters get into the pipeline for some of that federal broadcasting dollars. So I wanted to throw that out there. Barbara, that's probably not something you've considered in the past, but maybe there's some avenues where we can look to how we help minority broadcasters get into that pipeline.
I think it's a really interesting idea, and I think that is a follow-up with Tom.
Okay. Great. Thanks, Barbara.
And I'm going to ask Ron, would you think about that a little bit as well? That question, it's not exactly supplier diversity, but it has that aroma, if you will. So, if you can talk to both Tom and Jim and see if this isn't something that your committee can't look at.
Absolutely is supplier diversity. I would say, in terms of if those dollars, advertising dollars, are flowing back to minority-owned broadcast properties, that's part of how major corporations evaluate their supplier diversity spend.
Yeah, my thinking as well. So, anything else?
Well, if I can add just one thing on that, and Jim Winston's point, if my memory serves me correct, didn't the Clinton administration do an executive order during this last year is to look at that very point, that I think only 2% of advertising dollars go into ethnic-owned media, so it's not an unprecedented issue for the government to address.
The Clinton administration did an executive order on this very point, and in 2009, President Obama did an executive order telling his agencies to do more with small businesses. So they've been approaching this in a broad way, but we haven't gotten down to see the net results yet.
Okay. Yeah. Been a long time, huh?
Yes.
All right. Well, we're going to stand adjourned if there's nothing else to come before this august body, and watch your email for the next meeting. We'll try to meet again probably sometime in the fall. Trying to get all you guys together in the summertime is just really tough. So we'll see when we can get the room, and I'll talk with Tom and see when is best for us. But you'll just watch your email. I think that's the best way to do this. Meanwhile, if you've again, I would encourage you, if you're not on one of the task forces, get on. If you're on one and you'd like to get on another one, that's permitted. We'd like to do that. If you've got any thoughts or comments about this meeting or future meetings, please let me know, and Barbara as well. Again, thank you all for coming, and thank you for your time. It's much appreciated.